Let's say you're charged with a felony in Kentucky. The case is in district court where most felony cases start, and you have an arraignment upcoming. When do you get access to the evidence in your case? Well, in Kentucky, you may have to wait a while, and I'll explain in this video. Hello, my name is Abe Mashney. I'm the founding attorney of Mashney Law Criminal Defense here in Lexington, Kentucky. In my practice, I represent a lot of individuals charged with felonies in Kentucky, and I always have to explain when we will be getting the evidence in their case. So first, you need to know the basics for a felony case. Most felony cases get charged by a criminal complaint and begin in district court. In district court, there are two court appearances. There's the arraignment, where the charges are read, and a not guilty plea is entered. There's also a preliminary hearing. At the preliminary hearing, the government puts on proof, usually in the form of the officer testifying, as to why the defendant was charged. If the judge finds probable cause, then the case moves forward and the different prosecutor presents the case to a grand jury, and the case ultimately lands in circuit court where it will stay. I'll start by saying this. In our criminal system, you are entitled to all of the evidence the government intends to produce against you, both the good evidence and the bad evidence. But the ways that our rules are set up here in Kentucky, we do not get access to those materials until or if the case is indicted by the grand jury and the case is in circuit court. So you may ask, what are we entitled to in district court? Well, the answer is whatever's in the court's case file. Sometimes it could be just a bare bones criminal complaint. Sometimes it's a narrative form, arrest warrant. Sometimes it's a search warrant that details a lot of probable cause. Either way, it is not the full spectrum of the evidence. We don't get access to the body cam, supplemental police reports, audio, surveillance, none of that. And so that is not ideal for multiple reasons. As a defense attorney, I'm always going to try to be as prepared as possible going into any hearing. I would love to have access to the body camera prior to the preliminary hearing. The prosecutor has access to it, the officer has access to it, but on the defense side, we do not. So what you see a lot of times is asking questions that could very well be answered if we were able to get the body cam. And so it would cut down the hearing times, and I think it would streamline things greatly because we are just trying to search for answers and we don't have access, so there's going to be a lot more questions that have to be asked. But the biggest problem is when the prosecutor makes a misdemeanor offer in district court. And so what I mean by that is it's currently charged as a felony. They want to amend it to a misdemeanor and ask the client to plead guilty. Without the full access to the evidence, I'm not going to be able to tell my client if their rights were violated by an illegal search, by inappropriate questioning. Maybe the complaining witness said multiple inconsistent statements. We don't have access to that. So we have to make judgment calls, knowing all of the evidence that we can gather through interviews with the client to determine the strength of the Commonwealth's case. And so when the stakes are this high, that should not be the case. So Kentucky legislatures. I know this is a short session and I know this is not anywhere on the agenda, but please do us a favor and change the discovery rules so that criminal defendants get open access to discovery when they are charged, not months down the road. And so if you have a felony case and want to talk, please give us a call. We offer free case evaluations, and I'd be happy to discuss your defense strategies with you in your specific case. And as always, thanks for watching.